So good afternoon, I'm Norman Drickler. I'm the Interim Vice Chancellor for Research and Graduate Education. I want to thank all of you for joining us today for the first of a three-part series presented by WARF on technology commercialization and industry partnerships. And I'd also like to thank WARF for putting this series together. So whether you're new to campus or like me, you've been here for almost forever, this is a great opportunity to learn about the ever-changing landscape of patent law and patent eligibility. Today you will hear from Beth and Michael from WARF, who are experts in both of those areas. Today's session, though, is also a good reminder of what hasn't changed, and that what hasn't changed is the expectation that all university researchers who make discoveries during the course of the work that they're doing for the university should disclose any inventions to WARF. It's a requirement to disclose, but it also makes a lot of sense, both for you as a researcher and also for the university. So we've been really, truly fortunate in having WARF as an outstanding partner for more than 90 years now, and its expertise and financial support are really critical to the university's research success. So WARF is among the oldest and most successful tech transfer offices in the nation. They told me to say that. And as the designated patent and licensing organization for UW-Madison, it also advances our discoveries to the marketplace to benefit everybody across Wisconsin and across the world, and things ranging from smarter processors to human embryonic stem cells. So in fact, any licensing revenue that flows from your discoveries as WARF licenses patents that arise from your inventions directly benefits you, the researchers who made the invention, but also really substantially advances research at the university. The annual WARF grant is essential in providing substantial resources to allow us to recruit and retain outstanding faculty, to support student fellowships, to build new research programs, and overall advance the Wisconsin idea. So thank you again for your interest in today's topics, all your discoveries, both past, present, and future, that make the university really a world-class place to do research. So, hand it over to Mike.
Thanks, everyone. Thanks for coming, and thank you, Norm. He's been such a solid university citizen and done so much for the campus, and we've really been enjoying having him in his interim role at WARF. It's just been great to have you, so thanks again for coming today. As most of you know, WARF's mission is to support science research on this campus. We do that by granting money to the university to be used for basic science research, but we also do that by handling the management, the disclosure, the licensing of intellectual property. And that's really our chartered mission. It is why the IRS gives us a tax-exempt status, because we do that for the university. And so we really take that role seriously. We've talked recently about a couple of new initiatives we have, WARF Therapeutics, to help support the development of new medicines on campus. We have a new venture office, Mike Parch, who's leading that, who comes from that West Coast, to help us take that to the next level of expertise. These are really important things we're doing. Part of the reason we're doing this three-part series is we said we don't want people to forget about the basic bread and butter, the things we do, and that really core mission we have. Most of us at WARF spend most of our time thinking about how to best protect the intellectual property that comes from this campus and bring revenue back and get it used by the world. So that is what we do. Beth Werner is going to focus on that today to talk about the disclosure. We have two upcoming ones, one on industry agreements and one on some conflict of interest matters with Andrew Norman from the university. He does a really good talk on that. It refreshes my recollection about some of the details each time I hear him do it. So I would really encourage you to think about coming to enjoy those. And up next, let's have my colleague Beth Werner take it.
Thanks, Michael. Thanks, everyone, for coming today. And as has been said, my goal today is to teach you a little bit about the patent process, a little bit about the WARF process, and at the end of it, we're going to talk about some changes in patent law that have impacted how we can go about protecting the intellectual property on the campus. So the title of this is What's New and What Isn't in Advancing University Technologies. I'm actually going to swap it. Let's talk about what isn't new about advancing university technologies. And my first slide there is WARF. We are not new. We have been around since 1925. We're a nonprofit organization, so while we're on campus, we support the campus. We're not part of the university itself. We're a separate organization. And we're located in the WARF building. So if you guys don't know where that is, it's down on the west side of campus, close to the hospital, School of Pharmacy, School of Nursing. And I would encourage you, even after I talk to you about the formal process, if you want to talk to us about science, come on down. I'd love to talk to you about science. Our website has contact information. It's got little biographies about us. So if you can match an IP person to your scientific area of interest, and I'd love to hear about your science and just talk science with you. So best part of my job, I'm a science person, best part of my job, talking science to the scientists. So we've been around a long time, and the success of WARF is tied directly to the amazing research that goes on this campus. Without this amazing research, we'd have nothing to protect, we'd have nothing to license, get out to the community, to the market. And because of these successes, we do return revenue back to the university, which goes to support research, which yields additional inventions and other intellectual property, and thus the cycle continues. So when we talk about intellectual property, I talk about it in four main buckets. So there are patents, and the bulk of what we do at WARF is securing patents on inventions that arise out of the scientific research on campus. Probably 75 to 80% of what I do is dealing with the patent office and trying to get those patents to issue through the patent office. We can also register copyrights. We do a little bit of copyright work. Copyrights, they protect creative works that are put in tangible form. And that creative work can include computer code. So that is one thing we have been registering, I wouldn't say a lot, but more often than we have in the past, it's computer code. Computer science, computer coding has influenced every aspect of science, and we're seeing a lot of inventions in that space, and sometimes registering copyright is the best way to protect those sorts of inventions. I have only registered one copyright at WARF. It was when I first joined the organization, and it was around a historical film about WARF, and I have to admit, I have not actually watched the film. But the copyright process was really easy. Registering the copyright was also really easy, and someday I will sit down and watch this historical film about WARF. Another form of intellectual property we do work with are trademarks. We don't do a lot of trademark work at WARF, so trademarks are tied to commerce. And because WARF doesn't actually make the products, we're looking to license our intellectual property to companies who in turn make the products. We don't do a lot of trademark work. The trademark work I do is typically tied to the inventions being created. So I manage the cranberry portfolio. I don't know if you guys are aware, but we actually have an active cranberry breeding program going on campus. We have a number of varieties that have been licensed to cranberry growers in this state, and I get to manage the patents around the cranberry varieties. The plant breeders come up with the catchy names that are associated with the cranberry varieties, and we then can register to get trademark protection on those names, such as Sundance, Ruby Star, and the latest is Sweetie, which none of us are fully convinced that that's the right name, but it's a naturally high sweet cranberry, and that's what the name of that variety is going to be. So the trademark work I do is really tied more to inventions, not necessarily getting trademarks, because as I say, we don't make the products and we're not putting them into commerce. The last bucket I'll talk about, and I'm going to only talk about it here, it's trade secrets. And as the name implies, the key to the value of trade secrets is keeping them secret. People on campus talk a lot about their research. So there is very little that remains secret about the research going on this campus. And so it's just not something we do a lot of work with. One of the most famous trade secrets people are aware of is the Coca-Cola Formula. It is kept in a vault in Atlanta. There are pictures on the internet of this vault in Atlanta that has the actual formula of Coca-Cola that's kept as a trade secret. So as I said, we do a lot of patent work. So what is a patent? A patent is the right to exclude others from making, using, selling, or importing your invention. And patents also are not new. The patent system was actually settled in the Constitution, so it has been in existence for a very long time. Now, what's interesting about patents, it doesn't give you the right to practice your invention. Your invention may incorporate other people's patented inventions, in which case you'd have to take a license to these other patents in order to be able to make the product that you subsequently have patented. So it's kind of an interesting system. I think a lot of people do think, oh, I've got my issued patent, now I can go out and make my product and sell my product, and this will be great. That's not necessarily the case. You may have to look at getting licenses to other patents to actually make the product covered by your patent. It's a quid pro quo with the government. So the government is the one giving you this right to exclude others from making, using, and selling your invention. And they do that as an incentive for you to share the details of your innovation with the world. So basically, you teach others how to do your invention. In exchange for that, you get a 20-year right to exclude others from making, using, and selling that. Once that patent life is up, anybody who's now learned your invention can enter the market. So the lifetime, as I mentioned, is 20 years from the filing date of the US patent, and it can take about 2 to 5 years to get through the process. So you file your patent application, and then you spend a long time arguing with the Patent and Trademark Office about whether your invention actually warrants patents, whether you meet the requirements that the patent system sets out. And most of the cost associated with that argument with the Patent Office end up being attorney's fees. So we have a stable of outside attorneys that we use to actually draft our patent applications with the help of the inventors. And then they're the ones that are communicating with the Patent Office, and we monitor those communications and have input on that. And we need the technical experts many times to work with the Patent Office to explain the invention in better detail and educate the patent examiners about those inventions. On average, it runs about $30,000 for us to get a US patent through the whole process and get it to issuance. Now, this is just the US patent system. So countries around the world all have their own patent systems. Most of the requirements are somewhat streamlined, but everybody's going to charge you extra fees to file and to prosecute those patents around the rest of the world. So what are some of the requirements for patenting? The first one we always like to talk to is eligibility. And it used to be that this was a really easy thing. So basically, if you had something useful that wasn't just a mathematical formula, or you hadn't gone out to the marshland and found a native blueberry plant and then collected the blueberry plant and tried to patent that plant, that's a natural product. It's a product of nature. It exists in nature. It's for everyone to have access to. You could patent pretty much anything. You could patent machines, you could patent new materials, you could patent methods of making, of using, of purifying. It was a very broad definition, and some recent Supreme Court cases have started to narrow the definition of what is eligible for patenting. And I'll get into that at the end of the talk when I talk about what's new. And it's really clouded the system, at least one step of it, where we thought this was very clean and very clear. Now, for right now, the clearest requirement is novelty. Novelty is a yes-no, it's a yes-no question. Either your invention is new or it is not new. So if somebody else has publicly disclosed your invention before you filed that patent application, it's not new. If the Patent Office cites that and says you don't get a patent around this invention because somebody else actually had it before you, and it is exactly your invention, there's no recourse. There's no arguing with the Patent Office. It's a very quick process when they find that, because that's it, you're done. There is no arguing, it's not subjective, it's a yes-no question. Now, if you want to talk subjective, let's talk about the obviousness requirements. So your invention cannot be obvious over what's been done in the past. And this is probably where we spend most of our time arguing with the Patent Office, because imagine, they're looking in hindsight on an invention you've made. And I don't know about you guys, but I'm seeing these made for the buy this product on TV, and I'm thinking, well, how did I not come up with this $1 million idea? That's so obvious. I mean, it's so easy to look in hindsight at these things and think, well, I should have come up with that. And I don't know about you, but I did research in getting my PhD here, and none of my research was obvious. The Patent Office might think research is obvious, but trust me, it's just not the case. And yet everything with the Patent Office, that's the rejection we see the most from the patent examiners. The most reason for them is to tell us, no, we don't get a patent. It's because it's obvious over what's been done in the past. Or they find a reference in this journal, a reference in that journal, a reference in another journal, and each reference has a little piece of your invention. You put it together. Anyone could have read those 3 references and obviously would have come up with your invention. So that's the requirement, and as I say, we spend the most of the time arguing with the Patent Office. The other one is enablement and written description, and that gets back to that quid pro quo with the government. You have to teach them others in enough detail to be able to practice your invention in order to get that limited exclusivity. So the government has scientists that they've trained in patent law to review or examine your patents, and that communication will go back and forth with that patent examiner as you determine whether or not your invention actually meets these requirements for patenting. So one real key to getting a patent through the Patent Office is called prior art. And this is perhaps the most challenging aspect of doing academic technology transfer. Is prior art is all tied to public disclosures. Public disclosures of research. Public can be papers, it can be marketing information, it can be patents, and prior art is references from around the world. So I've had situations where we filed patents and we had some obscure reference from 1930 in a German journal that no one could read, The Patent Office found that though, and it was pretty spot on to what our invention was, unfortunately, so it really caused us some problems. So again, the Patent Office has access to all the references all over the world, and anything that another party has published or publicly disclosed before the filing date of your patent application will be art against your invention. And that will affect novelty, whether it's new or not, and it'll factor into that obviousness question. Now, the nice thing in the US is we actually get a 1-year grace period from when you publicly disclose your invention to be able to file a patent application. So basically, your prior art would only be 12 months plus a day from that filing date. And what's nice about that grace period in the US is, again, you guys talk about your research a lot. And I've had many instances where I've got inventors getting on a plane to go to a meeting and they think, oh, yeah, I'm doing a presentation and I didn't talk to you beforehand. What do I do? I've got 2 days now, and should we file something? Should we not file something? And one of the great things about working at WARF, we have the resources to be able to turn things around really quickly if we have to. So even with a couple days notice, I can look at something, we can make some decisions, and we could get something on file to beat that public disclosure. I prefer to have at least a couple weeks. So if you're thinking about preparing a presentation or a poster or writing up a manuscript, think about maybe talking to WARF if there's something in that work that you think, oh, yeah, I can see a company being interested in this, or I've got colleagues who are in this space who are really going to want this technology and want access to it. It's a great time to come and talk to us before that public disclosure happens and that 1-year patent clock starts ticking. And internationally, I should note, you have sacrificed your patent rights if you publicly disclose your invention before filing that patent application. And you can imagine, it's a deal with the government. They want you to teach others to do your invention, so the rest of the world says, hey, thank you for voluntarily teaching everyone to do your invention, no patent for you. So again, in the US, we've at least got that 1-year grace period, which we use and we depend on a lot in academic tech transfer. So let's talk a little bit more about public disclosures, because as I say, it's really important, and it is perhaps the most challenging aspect of what we do. And some public disclosures, this is just a list, just to give you some examples of public disclosures. A couple that I'll point out: departmental seminars are public disclosures, class projects are public disclosures, and I have students who will come in and they're like, well, yeah, I presented in a class, but nobody from the public would actually ever attend this class, so how is that a public disclosure? And it's not so much that the public doesn't attend your class, it's that someone from the public could, that it is open, that someone could come in, or that audience members could see that your other classmates are learning about your invention or your research. They go home or they talk to their roommates. They say, hey, I saw this really neat research going on, or wow, one of my classmates has this really cool project going on. That roommate could talk to somebody else, and all of a sudden, even though the public wasn't there, the public starts to learn about your research. So again, general rule of thumb is if someone from the public can walk in, even if no one could, consider that as likely a public disclosure. I think the other one that raises some eyebrows sometimes, I talk to people doing clinical trials down at the hospital, and patient consent forms, if they are detailed enough, could be considered a public disclosure as well. So we try to work with them on understanding what clinical trials they're working on and the technologies they've got, and whether we should be filing something before they actually start their clinical trials. Some things that are not a public disclosure. So I'll give you some examples of these. Submitting grants, manuscripts, abstracts to meeting. The submission is considered confidential, and so that's not going to be the public disclosure aspect of it. It's when it's publicly available. And certain meetings will publish abstracts online early. Certain journals will publish papers early. So you think your publication is one thing, and then all of a sudden we find out, oh no, it actually published online 2 weeks before we thought. That has come back a couple of times where we've missed that 1-year grace period by just a couple days because a journal published something online before we realized it was going to happen. The researcher didn't think about it. They thought, oh, we're still in that 1-year grace period. And then we do a little digging and find out, no, we missed it by just a couple days. So that has happened to us. So again, if in doubt, come and ask. I think that's really the take home on public disclosures, because it's really hard to say what will impact your patentability or not. Most of the time, general rule of thumb again, if you're going to publicly disclose something, it's going to impact your patentability somehow. So another thing that's not new is our WARF IP management process. So we've been managing IP since 1925 here on campus, and we have a pretty well set out process. And this is just sort of a cartoon depiction of our process, and I'll walk through the process step by step. And again, don't feel like you can only talk to us if you're going through this process. Come and talk to us anyway, early, often. Again, you can never talk to us too early, you can only talk to us too late. But the first step in the formal process is to have you fill out the invention disclosure report form. And we can email you that, that's on our website. It's a simple 4-page form. It should take maybe 30 to 40 minutes to fill out. I've had researchers send me a 20-page document, and I appreciate all the details on that form, but please don't spend hours and hours and hours working down the form. Just put enough detail in there to describe what the invention is. And these forms are actually shared with funding agencies, and I have had the NIH contact me a couple of times and say, hey, there's not enough detail on this invention disclosure report form for us to know what this invention is, and so I'll provide them a little bit more detail. So it has to have a little bit of detail to give people an idea of what the invention is, but it doesn't have to be all the data. It doesn't have to be you writing up a brand new paper. Now, if you've already got a manuscript and you're getting ready to submit that, just say see attached manuscript in that section and include the paper. There's no reason for you to fill out that section of the form when you've got a really great description in the form of a manuscript. We're going to ask you what makes it superior to what's out there. That can be 1 or 2 sentences. We're going to ask, when did you think of the invention and when did you first show that it actually worked? And those dates are important because every invention disclosure report form we get is submitted to the Vice Chancellor's office. And there are people there that will look at those dates, and then we'll also look, we're going to ask you who funded the work. They'll look at that as well, and they get to make the final determination of what funding has gone into that invention. And the funding becomes very important because if there is federal funding, there may be an obligation for you to work with WARF to secure that patent under the Federal Bayh-Dole Act. If there's third-party foundational funding, say the Cystic Fibrosis Foundation, they may have obligations in there that, yeah, if you have a patentable invention, we want to secure a patent on the invention that we've provided funding to make, and there may be that obligation. Companies as well, if they're sponsoring research in your labs, they're going to want to know if inventions are being made, and there'll probably be some obligations under that as well. So funding becomes very important, and again, the university gets to have the final say on that, but definitely take some time to think about what funding's contributed to your invention as well. We're going to ask you, have you or do you have plans to publicly disclose it? And I don't think I need to mention about the importance of public disclosure again, but we've talked about it. Definitely give us a heads up before that paper is going to be published. And we're going to ask who the inventors are. And we don't expect you to know how to determine inventorship. So inventorship and authorship are 2 very different things. Authorship is very fluid. You can add people who contributed materials to authorship. Inventorship's a question of law. And we have to get inventorship correct. If we don't, we can't enforce our patent. So we can't add people who aren't inventors, and we can't keep people off who are inventors, even though sometimes it might make our lives a lot easier. We have to get inventorship right, and we have to have an attorney make the final determination. What we're really looking for in that section is put down who made significant contributions to the invention that you're disclosing, and make a note if you've got collaborators outside of the university. So if you're working with other people at other universities, or you're working with a company to develop these things, we need to know if there are other people involved, because we may end up having a jointly owned patent if there's another entity that has an employee that's an inventor on our patent. So again, make your best guess. We'll talk about it when we sit down and meet. We don't expect you to get it right. And the nice thing is, you're not the one to tell people, oh, you can't be an inventor on the patent. That's actually pay my attorneys a good amount of money. They get to be the bad guys. So they actually are the ones that get to say, they'll do the inventorship determination, they'll break the bad news. You're not an inventor, here's why, and we have to go with that because, again, we have to get it right. So once you submit the invention disclosure report form, and I should say, you can submit that generally to our website, you can submit it to a specific intellectual property manager, so I'm one of 7 in the office, we all have different scientific expertise, so we work with the same inventors over and over again, and we have certain technology areas in our portfolio. I manage a lot of the pharmaceutical technologies, agricultural technologies, some of the clean technologies. So you can submit it that way, you can submit it to the website, it will get to the right person. We'll set up a meeting to go over the details of the invention. So we'll go over the data you have, we'll go over what your future plans are, we'll talk about that inventorship question, we'll talk about the funding, who's contributed, we'll talk about whether you got materials in from another entity, we'll talk about a lot of these little details, because ultimately, we, the intellectual property people, we have to write an executive summary of that invention. We have to be able to describe that invention, what that invention is, how strong the intellectual property protection could be around that invention. Are there patent and licensing obligations due to funding? We're going to talk about all of that, and every month we get together and we have a disclosure decision meeting at WARF. And so that meeting is made up of an internal committee at WARF, and it includes the intellectual property management staff, it includes the licensing staff, it includes senior management. It's a group of about 35 people with a variety of scientific backgrounds, a variety of business development, sales backgrounds, and we're all talking about the inventions that are disclosed to us over that month. And that group determines whether to accept or reject an invention. Our accept rate runs about 50%. And the criteria is, can we get intellectual property protection, or what kind of intellectual property protection are we looking at? How strong is it? How broad is the description of the invention we can secure with the patent office? Because if we can only get a patent that covers this much space, it leaves a lot of area for people to work around the patent, and they'll just design different things and not have to take a license to the patent at all. We need to know whether we can enforce the patent. So when we secure and we get an issued US patent, you get this lovely ribboned document from the patent office, and if you can't enforce it in court, what you have is a lovely ribbon document from the patent office, and you really don't have a lot of value to your patent. So for method patents especially, if a company's gonna practice a method internally, and the end product is such that we never know if they're practicing that method or patented method or not, it's really hard to enforce some of those method patents because we just won't know if a company's doing it or not. We are going to talk about the likelihood of finding a commercial partner. In certain technology areas, companies just aren't interested in licensing. They will wait until you sue them, and then maybe you force them to take a license, but some of them are just, that's their business model. And we're going to talk about the licensing return. I think if we think about it, if we're going to run on average $30,000 to secure a patent in the US, we have to make sure that the subsequent product that comes out of that isn't just making $20,000 over the life of the patent. I mean, that's financially, it just doesn't make a lot of sense. Now I say that, and yet again, one of the great things of WARF is we have resources and we have some latitude to take risks on technologies where maybe the answers to those questions could be possible. The potential commercial end game is huge, but the market may never get there. We can file on those. Not all technology transfer offices can do that, but we do have the resources to be able to take some flyers on technologies. And we can secure technologies in hopes of maybe securing additional funding. I mean, if you've got the startup companies, you're going to try to be developing that product, getting that issued patent may have some value from a marketing standpoint. So again, with WARF, we've got a little bit of latitude. It's not always just a bottom line, is this going to make the money or not make the money? We have a little bit of latitude on that too, but it is definitely something that we consider. So if the committee says yes, and they give me the green light, I get to hire the patent attorney, and then they're going to, well, I should note, we'll let you know what the committee says, yes or no. And the UW will do the equity review. That's the granting the funding source. You'll get a letter from the Vice Chancellor's office detailing what funding is contributed to the invention. And ultimately, if the decision is yes, then I'm going to get to hire the patent attorney. We're going to sit down with the patent attorney. We're going to go over the details of the invention again. And they're the ones that will draft up the patent application, circulate that for review. We submit it to the patent office, and then we wait, and we wait, and we wait. And then we'll get a notice from the patent office, and then we have to hurry, 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 because we got deadlines, and then we wait, and we wait. So that's the patent process. This is sort of just a basic timeline. It's a lot of hurry up and wait. So in this timeline, I've got a provisional patent application that I filed, and I'll just talk briefly about the provisional patent application. It's a stakeholder, a placeholder in the patent office. So in biology and chemistry, we do a lot of provisional patent application filing because that 1 year, that red section there, we have the ability for you guys to do additional work, additional research, maybe validate it a little bit further, see if it's really going to work the way we wanted it to work, try it in different systems. So that 1 year, we can take all that additional data you've accumulated over that year and then ultimately file a formal utility patent application at that 1 year. So we actually use a lot of provisional patent applications in chemistry and biology, biotech, and pharma. Ultimately, your application is going to publish. So it publishes 18 months from the filing date. And that's usually around the time that a patent examiner will start picking it up and we'll start hearing from the patent office. Now, I have had one instance in my 14 years where the first communication we got from the patent office was, you have a patentable invention, you have some allowance, you just pay the fee, this is great. Very exciting, because in the space I work in, I never hear that right away from the patent office. It's always no, 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 and then maybe yes towards the end. But we did start scratching our heads thinking, well, maybe we should have asked for more from the patent office. If right off the bat they say yes, we maybe should have tried to get it a little bit broader. Most of the times it's no, and in my areas it can be no a long time. I think the longest it's taken me to get a patent to issue was 9 or 10 years. That patent costs significantly more than $30,000, I will tell you. Those are anomalies. Most of the time it is more that 2 to 5 years, and it really is technology area dependent. So there are certain technology areas where they just don't see as much filing, and the patent office will pick those up quickly and examine those quickly. There are certain technology areas where there's a huge backlog, there's a lot of inventing going on, and it just takes a lot longer to get those through the patent office. Ultimately, after your patent issues, you're not done yet. There are 3 maintenance fees that come due at the US Patent and Trademark Office, and those happen around 4, 7, and 11 years out of your 20 years of patent life. And at that point, we at WARF start looking as to whether the technology is obsolete, whether something's bypassed it and now there's just not the value we thought. We'll look to see maybe we've done additional commercial development work and it just doesn't work the way we need it to work for a commercial company to take it. So we do drop some of our issued patents, usually not at the first maintenance fee, but maybe the second or third. The fees escalate exponentially as you go, first, second, and third. So especially if you're thinking about companies and managing your patent portfolios, keep in mind that that third fee can get pretty costly. So you want to make sure that it's a patent that still has some strategic value for you. And we do the same thing in managing our patent portfolios. And I mentioned a little bit about the public disclosures. So notice that that's on here about 20 different times in my talk, how important public disclosures are, so keep that in mind. While the patent is being prepared and ultimately it gets filed, once it's filed is when the licensing team really starts actively marketing the invention, actively marketing the technology, and looking at finding licensing partners. So I have one token licensing slide, because I don't want to steal the thunder from the next WARF Essential Topics, which is going to be geared much more towards contract language and licensing. But just to sort of introduce the licensing concept. So a patent's a right to exclude others from making, using, and selling your invention. A license allows someone to make, use, or sell your invention. So it's like removing that exclusion, if you can think of it in that sort of, those sort of terms. And it can be one entity, which means that it's an exclusive right to practice your invention, or it can be multiple entities. You could license it to a number of different parties. That's called a non-exclusive right. You could license it exclusively to one entity in the US, you could license it exclusively to another entity in China, you could license it exclusively to another. That's geographic exclusivity. So there are so many flavors of licensing that I don't even know. There's not like there's a template and a flow chart of here's how a license works. It's just, every license has its own flavor, its own life, its own negotiation. What the licensee is going to provide is they're going to provide the development and the commercialization. And ultimately, they're going to pay to get access to those patents. So they're going to pay us usually an upfront fee. There may be milestones depending on that development timeline and developmental process. And if they do have success in launching a product and selling a product, there will be royalties from that product sale that comes back to WARF, and that makes up both the revenue that we give to the inventors, which is 20% of our licensing revenue goes to the inventors, 15% of the revenue goes to the department of the inventors, and the remaining amount is part of the WARF gift every year to the university. So that's where that licensing revenue is coming from. It's upfront fees, royalty fees, milestones. There may be annual minimum royalties, and we charge annual minimum fees because what we don't want is we don't want a company licensing our technology and just sitting it on a shelf and never developing it. So if they have to pay just to have access to that patent, it's sort of an incentivizer to say, okay, you guys better spend the money to develop this because otherwise you're just writing us a check every year just to have the access. And we do have some obligations under that federal Bayh-Dole Act I was talking about. The Bayh-Dole Act was set up in 1980, and that gave universities the right to take assignment, to take title in inventions made under federal funding. And part of the obligations under Bayh-Dole is that we do get it developed. So we will have a development section in a license where a company explains to us the timeline, what steps they're going to take, because we have an obligation under federal law to make sure it's getting developed. There are other obligations. Probably the other one that comes up a lot when we're talking to companies is the obligation to manufacture in the US. In certain technology areas, that's not a problem. In other technology areas, that's a big hurdle to commercialization. So there are ways of getting exceptions to that. It's not necessarily trivial, but again, that's something that we'll talk to the potential licensee about. A timeline for a license can vary from months to years, and it really depends on the technology and the market area. So that's my one token slide about licensing. Again, come back on April 16th, same time, 4 to 5, learn more about licensing. So then let's talk about what's new in advancing university technologies. And I'm preparing these slides and I'm like, wow, I really wish that I had a lot of good news in the what's new section, but I don't really have a lot of good news in the what's new section, which is a little unfortunate. So the first thing is not all that new anymore. We've now been living under this for a while, and I think we've kind of come to terms with most of it, I would say. It's the Patent Reform Act, the America Invents Act. So it was the first real meaningful patent law reform that's happened in decades. And it took a long time to get this act through Congress ultimately. It was passed in 2011 and implemented in 2013. And perhaps the thing that caught everyone's attention the most was it changed our system from a first to invent to a first inventor to file system. So what does that mean? Before this act passed, if you had invented something in your garage and you were still working on it, and unbeknownst to you, somebody else at a company was working on it as well, they've got lots more resources, a lot more people, they can take risks, they file their patent application, and say 6 months later, you say, yeah, this invention really does work well, I think I can turn this into a product, I'm gonna file a patent application as well. Now the company beat you to the patent office by 6 months, but there was a process in place with the patent office, and if you could prove to them that you came up with the idea first, and you actually worked on it diligently to develop it, and that was before the company was starting to work on theirs, you could still get the patent even though you were the second person to file because you were the first person to invent it. That's not the case in the rest of the world. The rest of the world has it, it's a race to the patent office. It's whoever files that patent application first, they're the ones that are gonna get the patent. It doesn't matter if you sat and worked on it for 8 months or 2 years or whatever, whoever's first. It's a very simple process. I mean, I think the patent office is going to have a lot easier time dealing with that than the trying to figure out who invented something first because it's a date. It's did someone beat you or did they not? And I think we were really concerned about getting scooped on this race to the patent office. And I think it's turned out that so far, knock on wood, I haven't had any situations where I've been rejected because someone else filed a patent application before me. So that's been, I think, somewhat reassuring, let's say. And aligning our patent system with the rest of the world does make some sense if you think about it from a commercial standpoint. So let's say before the patent law changed, you had a technology, like the one that I was talking about, the company beat you to the patent office by 6 months. You prove you invented it first, you get the patent in the US. The rest of the world, it's a race to the patent office. They beat you by 6 months. So the company has the rights to the invention in the rest of the world, but you have the rights to the invention in the US. Well, now you gotta come up to some agreement because they can't sell their product in the US without rights to your patent, you can't sell in the rest of the world without rights to their patent, or if other companies wanted to license the technology, they gotta take 2 different licenses. So this should solve some of that, not all of it, where at least it will be that race to the patent office throughout all of the world. Fortunately for us, the 1-year grace period was preserved. There was some talk when that was going through different committee meetings and kind of evolving that they were going to do away with it and really align our patent system like the rest of the world, and that would have really been detrimental to academic tech transfer offices, where again, we're filing many times after something's been publicly disclosed. And you can no longer patent an invention someone else publicly disclosed before you. There was a route before the patent law changed that if, say, a publication came out 3 months before you filed your patent application, if you could prove you had the invention before that, again, it was first to invent. So you were the inventor, and you could still get a patent even though someone else had published something, say, 3 months before your patent application. That is not the case anymore. So, and sad story, I actually had an invention. We were trying to prepare it and get it filed before the law changed in 2013, and we were waiting for the researcher on campus to make one final review. It was a gene patent. And we were just getting ready to file. She gets a notification that a paper from a competitor publishes, and it is that gene sequence. And it beat us by 2 days, I think. It had published 2 days before we were getting ready to file. So we scrapped the whole thing. We didn't file the application because once the patent law changed, there was no route to us proving that she had invented it first. And so we didn't have a novel invention anymore, and there was no point in spending the money on it. So that really was sort of the real world of, oh boy, are we in trouble here? But again, I think we've all learned to live with it. There are some other changes that could crop up as being problematic for us. I won't get into details about that, but that was the one that I think scared a lot of people, and it hasn't, again, knock on wood, been too bad yet. So patent eligibility. Let's talk about patent subject matter eligibility. This isn't the only legally type stuff I've put in this talk, so if you're not already asleep, if you read this, you might actually fall asleep. But this was the first description on what subject matter is eligible for patents. So again, as I mentioned, we never really thought mathematical formulas or kind of abstract thoughts or ideas were patentable. You can't just go out and pick a flower out of the woods and say, I'm going to patent this flower because that is natural, that's a product of nature. But the actual description of what can be patented is whoever invents or discovers any new and useful process, machine, manufacture, composition of matter, or any improvement. So it's really broad. I mean, it covers lots of stuff. And where we always really glommed onto this was that useful term. So we always called this requirement utility. It had to be useful. That was what, because otherwise, I mean, it covers pretty much anything under the sun. And so utility was what we knew this as, and now that's not the case. Now the Supreme Court has taken a couple of cases and that has changed. And they're really focusing on abstract ideas and products of nature and natural phenomena. So this was what it used to be. It was lovely. You could pretty much ask, is it useful? Has it been touched by the hand of man or manipulated by the hand of man or made by the hand of man? And if the answer to that was yes, and you can see how nice and dark my arrow was, because the bulk of what we did, it was yes. We had no problem meeting this requirement. And if it's not useful, or it wasn't somehow manipulated, made, touched by the hand of man, it couldn't be patented. So that was great. It's not as great anymore. So the Supreme Court, I'm going to talk about two cases. They happened in 2012 and 2013. This one's a little bit easier to sort of get your head around, I think. And this is the Association for Molecular Pathology versus Myriad, and this is all around the BRCA genes. So Myriad had licensed in a gene patent that was actually filed by a university, and this BRCA gene, there are mutations in this gene that are correlated tightly with developing breast cancer or ovarian cancer. So it was a diagnostic screen that people would get to determine, are you at high risk of breast cancer? If you do have cancer, is it because of the mutations in BRCA1 and BRCA2 are the two genes? Myriad actually co-invented the patent on the BRCA2 gene with this university as well. Well, there was a lot of, let's call it kerfuffle, about whether someone should be able to patent genes, because I have my genes and you have your genes and the tree over there has its genes, and genes are in nature, and how can we patent genes? This is awful. It's making diagnostic techs super expensive, so it's not competitive, people can't afford these things. Should genes actually be patented? And the kicker was, no one could ever patent my genes in the past. I mean, it wasn't something that was isolated or touched by the hand of man. If you isolated a gene, now it's no longer in the genome. It is different chemically than something that is in nature. The Supreme Court, however, did not see it that way. So their logic was, because the information conveyed by the isolated gene is the same as the information conveyed by the gene and the genome, it is a product of nature, and it is not patent eligible. So when this decision came down, we all went, oh, because I've got a huge portfolio of isolated genes, patents around isolated genes, and you could use those to create transgenic plants, or you could put them into bacteria and yeast and do cool things with them. I mean, there were lots of different uses for these genes, but we thought the isolated gene was really the strongest patent. It didn't matter what people did with that isolated gene. It's a new gene. We have a use for it. It should be some patentable. All of a sudden, all those issued patents are no longer enforceable, and we just have a bunch of really nice paper documents with cool ribbon diagrams on them. So methods of using natural products or methods of purifying, isolating natural products are still potentially patent eligible, but the Patent Office looked at the Supreme Court decision and they expanded it to not just cover isolated genes, but also to cover isolated natural proteins and isolated small molecules. And it's the small molecule one. I mean, the protein one bothers me a little bit. It's the small molecule one that really gets to me, though, because I do have a lot of researchers on campus who are trying to identify natural products that could be the next antibiotics, they could be the next anti-cancer agents, anti-inflammatory agents, and I can no longer, in the US, get a patent on the chemical composition of this new chemical molecule, because the Patent Office says that's a natural product and it's not patent. It's no longer patent eligible. I don't have to, they don't worry about if it's new or if it's not obvious or not. It's not even eligible to be patented because it is a product of nature. And it's something that has caught enough legislature's attention that now there's been some discussions in DC about creating some legislative fixes for this and for the next case that I'll talk about. So again, there are still ways we can patent uses of natural products. So I won't tell you that, oh, natural products just flat out don't even waste your time. There's still value to it. It's just unfortunate that this happened to really cloud what was a very simple, yes, this is a patentable invention. The next one I'll talk about is around diagnostics and biomarkers. So this case was decided in 2012. It's Mayo versus Prometheus. And Prometheus was the company, they had developed this test, and it was centered around, I won't get into too many of the gory details, giving someone this drug, recognizing a range of metabolites in the blood that actually proved that that was the efficacious dose of the drug. If the metabolites fell outside of that range, the doctor should either increase the dose of the drug or decrease the dose of the drug. And we looked at it and said, well, as long as the range wasn't obvious, I mean, that's something no one really looked at that metabolite before and correlated it to activity of that drug and therapeutic success. So this is patentable. Yeah, the Supreme Court didn't think that either. So in the Supreme Court's eyes, the body is, through natural phenomenon, creating that metabolism. And then a person is looking at the ranges that are being measured and making a decision in their head about what to do about that, and changing doses is something that's common practice. So no longer is something like that patent eligible. Well, again, all of a sudden I've got specific gene mutations that have been correlated with diseases. I've got gene panels where the expression levels of different genes are correlated with diseases. I have all these things pending in the patent office, and now I don't know if they're patent eligible or not. And it really has been a problem in the diagnostic space. And this is another case that, again, the legislature is going to start trying to come up with some legislative solutions to clarify what is patent, because we have to have patents around diagnostic tools. People just aren't going to, companies aren't going to spend the money to develop these things and take them through regulatory without having some market exclusivity. So this is my sad flow chart at the end. Is it useful? Yes. Is it not a natural product? Maybe. Is it not an abstract idea? I think so. Not a law of nature? Well, all inventions, even a device, is going to require some sort of application of a law of nature. Is it not a natural phenomenon? I don't know. So maybe yes, maybe no. I kind of just throw my shoulder or my hands up, and we, again, being WARF and having the resources, we can fight with the patent office, and I've been working with some attorneys to try to figure out what language can be used to get some of this stuff through the patent office. Most tech transfer offices don't have the latitude to do that, but we at WARF, fortunately, do. There was one last section I was going to talk to, but I am running out of time, and that's just the pharmaceutical space. So I'll skip over that, what was the case in the pharmaceuticals, and just talk about pharmaceuticals now. The pharmaceutical, changes in the pharmaceutical commercialization is not due to courts necessarily. There was a court case that came out that said you can no longer patent drug targets. Or I shouldn't say you can no longer patent drug targets. You can no longer collect royalties on any drug made towards a patented drug target. So you can get a patent on a drug target and a patent to any modulator of that drug target, and then collect royalties if a company developed a modulator, a drug, to that drug target. Well, that court case came down and said you couldn't do that anymore, and everyone said, well, there's not a lot of value if we can't collect royalties on the drugs to be patenting drug targets. So we stopped patenting drug targets, and drug companies still would take early stage technologies in and do some development work and take on some of the risk, and that changed probably 8 or 9 years ago. We just saw that interest dry up. So really what drug companies want is they want you, the academic researcher, to identify the target, validate the target, come up with the lead compounds, test the lead compounds, validate the lead compounds, do the round of medicinal chemistry, take it to phase 1 clinicals, take it to phase 2 clinical trials, and then maybe they'll be interested. And the reality is, no one in academia is going to have the resources to do that. So you're seeing a lot of startup companies in the pharmaceutical space who are trying to do that development work, and then the big companies buy the medium-sized small companies. And we at WARF have recognized this problem for some time now and started up the WARF Therapeutics group. We pitched that down here. The big rollout was down here, where we've actually hired drug industry experts, medicinal chemists from the drug industry, to help take some of this early stage drug target technology and develop compounds to it and try to de-risk it enough that we can get pharmaceutical companies interested in licensing these technologies. So I was going to say with drug targets, I can't do anything with them. Now I'll tell you, if you've got drug targets, I may not be able to patent them, but I still want to hear about them. So again, it's coming out, west side of campus, big tall building. Love to hear from you and learn about your science. These are just the take homes, just to end it. Public disclosures, I can't stress enough how much that impacts your patentability. So keep that in mind when you're getting ready to publicly disclose. Maybe come and talk to us at that point. Patent law is fluid and evolves as courts rule in patent disputes. That means something that was patentable may no longer be patentable. That's not my fault. I'll do the best I can, but if you want to get mad at somebody, get mad at the courts of the patent office, I guess. And you can never talk to WARF too early about your invention, but you certainly can talk to us too late. So that, I think, is the most important. With that, I'll turn it over to questions. Here.
Thank you. My question has to do with patents that are not funded by federal money. The federal government uses that patent. Are they subject to a license?
if it is not federally funded, then yes, would be my answer, although I'm trying to think of any examples of there being a license the federal government has taken for technology. But just because the patent system is run through the federal government doesn't mean that they have ownership in all of those patented inventions.
It is true that you can enforce against the government. Because it's the government, they have to give you leave to enforce against them. And so you have to sue in a special court in Washington, D.C. But you can collect licensing royalties or some other remuneration for using the invention. So it is possible. We don't have many examples. I don't have any examples of that from campus because so much of our technology is federally funded. Yeah, I hope that question was probably connected to something. Yeah.
Is that the Court of Customs and Patent Appeals?
Yeah.
So, sorry. My question kind of pertains to the fact that a lot of discovery work now isn't in just one university, and a lot of it's collaboration across multiple universities, each having their own tech transfer licensing departments. So I just wonder if you could speak a little bit to how WARF in the process collaborates with other universities and whose responsibility those communications go through.
So wrestling battle royale, and we always win. No, it's we actually have a really good relationship with the other universities. We do what are called interinstitutional agreements with other universities all the time. So if there's a collaborator from another university, they are an inventor on an invention, we would have ownership to the invention, the other university has ownership to the invention. We then do a legal agreement with that other university, and we have a discussion. Who should take the lead in securing the patent around it? Who should take the lead in trying to find the licensing partners and bringing the revenue in? And how are the costs and the revenue going to be split? So all of that is detailed in a legal agreement anytime one of these joint invention happens. We do it all the time. We do it a lot with universities in this country, and we've started to do it more and more with universities around the rest of the world as well. That's a good question. Yeah, question up here?
Early in your talk, you quoted 2,300 patents, roughly, and about 1,600 licenses. But what fraction of that 2,300 was actually licensed? I presume some of those were multiple licenses.
It is a good question, yes. So, Michael, do you know off the top of your head what the percent of our patents licensed are? That is very common in a license. Instead of licensing just a single patent, there will be a portfolio of patents. So you may have 2, you may have 20, you may have 40 patents in a single license, and not all technologies get licensed. I always thought it was more like an 80-20 rule, but I think our numbers are better than that even.
It's weird. If you look at all of our cases, it's just over half that are licensed. Now, a lot of them are fairly new, so they might still get licensed in the future, so that might be a little bit biased towards a low number. But again, I would remind everyone, most of those don't bring in a lot of money. It really is just a few that account for most of it. So our percentage when we compare it to other universities is about average, a little bit higher, I think, in terms of how much we have licensed out.
Question back here?
So Beth, great job. So I'm an inventor, and I've listened to you, and you've talked about $30,000 as an average cost for a patent, and you've talked about fees that you pay once the patent has been issued, and you've talked about licensing. I don't have that money. Where do I find it?
The good news for you, Tim, is you don't have to pay anything to use our services at WARF. No, I appreciate the question, and I didn't touch on that, and I should have. So the services at WARF are free. I mean, we're going to assume all of the risks. We're going to pay all those patent attorney costs. We're going to pay for attorneys to review the licenses. We're going to pay for contracts administrators to make sure that licensees are actually doing what they're supposed to be doing. In exchange for that, we're going to share 20% of the licensing revenue with you, the inventor. That is for the entire inventor group, so it would be split evenly. If there's one inventor, they get the whole 20%. If there's 2, it's 10% each. 15% will go to the inventors' departments, and the rest is part of the university gift of book endowment. But that's a great question. So it costs you nothing outside of time, and I will try to stress again, we try not to make this a time sink for you guys. I mean, we realize you are researchers first and inventors 10th, 12th, 15th. I'm not sure how far down the list you're inventors. And we don't want it to be a time sink. You're going to have to spend some time. I mean, I'm not going to say we can make it time free, but that is what you are investing. is the time. We don't have you pay for any of the fees or costs. No more questions?
Thank you. You didn't talk about the design patents yet. Where does that fit in the realm of things, et cetera?
Sure, yeah, I didn't really go into the details of all the different types of patents. So there are three main buckets of patents. The utility patents are what we typically do. That's your typical patent invention. You think of doing research and coming up with a device or a machine or material. There are plant patents, which will cover certain classes of plants, and then there are design patents. And design patents are just as they are described. They cover designs. The design can't have a utility, it can't have a use, it is just sort of the artistic design of something. I honestly, I'd like to say that I'm an expert in design patents. I'm not. I don't know that I've ever filed a design patent. I think we have at WARF filed a couple of design patents. We just don't see a lot of design patents. And again, some of that, it almost bleeds into that trademark idea of, are you having a design patent that correlates with a brand around a product or a company or something like that. And we just don't do that sort of work. So yeah, design patents do exist. There's a format. They're very simple compared to your utility patents. So really the costs are significantly less in design patents and plant patents because the rules and the requirements on filling out that patent application, it's almost formulaic in a way. So the costs are a lot less than getting that utility patent. But it's not something we do a lot of. Yeah, another question?
What is a good rule of thumb that researchers can keep in mind when they're trying to decide whether they should file a patent on their new research, or whether they should just submit their results to an academic journal? Should they be talking with their PIs and doing some sort of a cost-benefit analysis?
If you want to, that would be great, but we don't ask researchers to do that. I don't have a checklist of what makes up an invention we might be interested in. So I can't give you just if this is yes, this is yes, this is yes, come talk to WARF. I think when you're dealing with your research, anything where it's like, wow, that really was surprising, or that really is shocking how good that is. Or you guys are going to know the industry and your collaborators and your colleagues as well. Is this something that a lot of people are going to be interested in? We get technologies that they do solve a problem, but it's a problem for 5 researchers in the country, in which case it's really going to be hard for us to file a patent, secure a license, make enough money off of that, the royalties on product sales to 5 researchers. So we consider that, and we don't expect you to look into that. I think the best rule of thumb is, if something catches your eye in your research and you think, yeah, I could see this having some commercial interest or colleagues interested, or as you're preparing your manuscript, it's a good thing to think of, hey, have I talked to WARF about this? We may talk to you and say, you know what, I just am not sure you got an invention yet, so maybe if you did X, Y, and Z at some point, you come back to us. You're then going to publish that work, and that work will be prior art against future patents, and we have to balance that. And there's no yes or no right, wrong answer to that. It's all case by case, balancing the importance of your publication, balancing how different that future work is going to be to what you're publishing. So what are our chances of getting that patent out in the future? But yeah, we don't expect you to come to WARF and say, yes, I for sure have an invention, and here are the benefits. When we talk about what makes it superior, here are the hard numbers. We'd love to see hard numbers, but we're also realists, and we know that most researchers on campus aren't going to come up with the hard numbers for us. We do have some resources in WARF to look into, sort of those cost-benefit analysis as well, so that is something we can do for you guys as well. 2 more questions. My little cue card says.
I was wondering if you could expand a bit upon what constitutes obviousness in a plant variety.
Oh, I wish I could. So when I first joined WARF, I got a lot of plant technologies in my portfolio, and I never really had any problem with cranberries. We would fill out, it's a plant patent, so again, kind of like the design patent question, a plant patent is very formulaic. Here's the botanical description of it, here's a comparison to what's been out there in the past. We are claiming this specific variety. Pretty simple, pretty straightforward, pretty inexpensive. I have had the worst luck the last 2 cranberry varieties I've filed because the patent office seems to think that our varieties are obvious over the parent varieties that are commercially available, even though we have pointed out botanical differences, be it flowering earlier in the season or a deeper color red, or they've come back and said, well, because we didn't test them in cranberry bogs side by side, the different environmental conditions could be impacting that. And we're like, well, we don't have an unlimited amount of bog space to be doing field trials of every related variety with our variety. So let's be a little realistic on this. It has to be a new variety, and there has to be a way for you to just describe what makes it different than what other varieties are out there, the closest varieties. That's what the patent office says, is really the description needs to be compare it to the closest varieties out there. Most of the time, those are the parental strains that have gone into the breeding of the variety, but maybe there's something else that's close out there as well. Or the patent office will identify something that's close, and then the burden falls on you to explain why yours is different. In the past, like I say, obviousness has not been an issue with plat patents. It really has been a very streamlined, nice process, but I'm not sure what they've told the examiners in the plat patent section, but it has become more challenging around that. So that would be my suggestion, is if you're developing a new variety, really make careful notes of any and all differences of your variety to what's out there. One last question, yeah?
Yeah, thanks for the presentation and being here. Another question of category that comes up in my field, how about simulations, whether it's kind of how you mathematically model physics or execute the math or even visualize and interpret?
That is also a great question. So I will, full disclosure, not my area of expertise, so I'll do the best I can with it. I would say that, so computer programs, which are what are going to be executing most of this mathematical modeling, computer programs are patent eligible subject matter technically, so they can be patented. I would say there have been some recent court decisions as well in the computer software space that has made getting algorithm patents through the patent office challenging, and they tend to be very narrow. So in the computer science space, it can sometimes be hard to get a patent of breadth and get it quickly enough through the patent office because you can't sit there for 5 years when other people are working on the next simulation, the next imaging. So I would say that that technology area is something that can be patented, but it is very challenging to define what is obvious, what is it not, it can't be an abstract idea. Is it just a computer system practicing a mathematical formula or practicing an idea? The patent office has really come down hard on that because technology advances. I mean, patent law shouldn't be static. As technology advances, it should evolve to recognize the evolution in the technology areas as well. And if computer systems are now able to really do these amazing calculations and these amazing processes, just having the technology isn't what's going to make it an invention. There has to be something else that's behind just the computer processing things. That's that aha inventiveness. So a lot of times when we're talking about software programs, we're looking much more at the code and protecting the code than an invention. But that's not mutually exclusive. We've got inventions where we've done both. We'll patent something, we'll get copyright protection on the code, and go from there. Cool. Well, thanks again, everyone. I appreciate it. And please come and talk to me about science so I don't have to talk to lawyers every day. No offense, Michael. Thanks.